Good day, Crime Talk aficionados. I'm coming to you on a Saturday. So what does that mean? That's right. It's the weekly recap of all the top stories here on Crime Talk. And this week, we were on the road. So hopefully you enjoy the stories and maybe the beautiful scenery in the background. Have a wonderful weekend, and we'll see you Monday on Crime Talk.
First on the docket, Lori Vallow, Chad Daybell. There's always something going on in this particular case. Today, it's initial disclosures. The government in the homicide case has to turn everything over, and just like the previous cases, they have to disclose what they have as far as evidence. And here the state says, guess what? Anything that we've already turned over to you in the previous cases, we're going to turn it over to you again so that you can't say that we didn't turn it over to you or that we missed it by mistake. Remember all that back and forth about not trusting the government and not turning anything over? The government's going to make sure on this homicide case there are no allegations of doing anything wrong.
Lori Vallow's attorney, Mark Means, is making more demands. Now, when your client is found to be not competent and they go off to the state hospital for restoration of competency, let's face it, the attorneys are not doctors. They are not going to get involved in the day-to-day treatment of their client. That's simply not their bailiwick. But Mark Means, that's right, he wants to have it his way. In a document filed Friday, Mark Means wants to know everything that's taking place because he believes his client is in a fragile mental state. And he wants to know everything that the prosecutors have told the doctors at the state hospital. Well, I know Mr. Means hasn't done a competency evaluation before. This is his first one. And in the restoration process, the doctors that are assigned to the case will reach out oftentimes and talk to the defense attorneys and see what their issues may be, particularly as it's been indicated in this case that Lori Vallow cannot assist in her own defense, which would make me think that there is some sort of delusional situation going on there where maybe she truly believes all this end of the world stuff so wholeheartedly that it's preventing the defense preparing for their case. Means is also asking for all conversations about Daybell's treatment, transfer to the facility, and any other issues regarding her competency while at the state facility. Means is also asking that Judge Boyce order private and confidential access to Lori Vallow while she receives treatment. Now, I'm not sure that the judge has any jurisdiction over there to tell the hospital how to run their show. Like I said, I've never seen a situation when your client goes off for restoration that the attorney is going to go visit with them in any way. Maybe the fact that Mr. Means is now being paid by the state, he believes that he needs to delve into this much deeper. Who knows? He's taking a very personal interest in Lori Vallow's treatment. So normally when somebody does go off to restoration, the case is paused. Once the court determines that there is an issue of competency and the defendant needs to be restored, the case is paused. Nothing further takes place. I don't think the court is going to entertain any of these motions, or shouldn't, until there's a competency evaluation done at the state hospital. Like I said, the Idaho law states that Lori Vallow will be held for 90 days to restore her competency. If that happens, court proceedings will then resume as normal. If not, the stay extends another 180 days, and then the treatment would continue based upon further stays and evaluation. Hopefully, she's restored to competency so that this matter can move forward as expeditiously as possible.
Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did.
All right, next on the docket. Okay, we talked the other day, and I'm telling you, I just have a hunch that this is going to be a very interesting case. This is the case of the wife and a son of a very prominent family. The father is an attorney. The great-grandfather was an attorney going back to turn of this 1908 in South Carolina. The young Paul Murdaugh got into a little bit of trouble. He was involved in a boating accident while he was allegedly intoxicated. Criminal charges were filed, and then the case was dismissed, perhaps because of who he was. Well, the civil case was still ongoing, but the father and the spouse of Maggie Murdaugh showed up the other day at their hunting cabin and found both his wife and his son had been shot. They had been murdered. So the father and the husband of the deceased in this particular case, Alex Murdaugh, is not considered a suspect in any way whatsoever. The cause of death for both victims has been released in the autopsy, and it's multiple gunshot wounds. Why is that significant? Because, well, no one was really sure at first. Was this some sort of murder-suicide? Well, it appears not the case. Must not have had the weapons remain behind as well. So who would want to kill these two individuals? A lot of speculation. The word is that Paul Murdaugh has quite a temper and can get very angry when he drinks. Perhaps somebody wasn't amused by his drunken antics. More is going to be investigated in this case. They're going to find out who did this simply for the fact of who their family was, both Paul and Maggie Murdaugh. This one, I think, is going to be a made-for-TV movie. That's just my hunch. We'll see how it plays out. And if I'm wrong, I will let you know. The prosecutors agree with my analysis that Mark Means' request to be involved with Lori Vallow's competency is absolutely ridiculous. We talked about it the other day that the Mark Means filed a motion on behalf of Lori Vallow stating that there was some sort of communication between the state hospital and the district attorney's office, and there may be some abuse taking place. Once again, Mark Means isn't being candid with the court, and the prosecutors state that he forgot one important detail. Oh, that's right. That they were the ones that notified Mark Means of the conversation from the mental hospital in regards to Lori Vallow. Oh, yeah, I'm telling you, this guy has burned so many bridges and lost so much credibility because he just can't seem to grasp telling the truth. No attorney is going to be involved in a client's competency restoration. Unless they are a medical doctor, it's simply not going to happen. I don't think the judge is going to even hold a hearing on this because the request is so ridiculous. And even if it were done, it would take months to schedule something the way things are going in Idaho. Next on the docket, Josh Duggar wants to delay his trial. That's right. The TLC reality show star, I guess has been reality show star, wants to delay his trial. And the reason for that is, as well, his attorney says that he's really busy. And second, the defense has now retained an independent computer forensic expert who must conduct a computer forensic examination to each of the devices at issue. The defense is saying that this is going to take a lot of time, and it's going to have to take review at the government facility. Why? Because the images contain really gross stuff. As you may recall, at the detention hearing for Mr. Duggar, the agents described what he saw on Josh Duggar's computer as, quote, the top 5 worst of the worst files he has ever examined, end quote. Okay? I'm telling you, of all the cases I've done, these are the cases that are worst. I could eat my lunch looking at autopsy photos and not have an issue. The only time I ever felt nauseous looking at evidence was when I had to go review evidence in a case similar to this. It is nasty, nasty stuff. And unless the defense can come up with something to say that Mr. Duggar was not the one using the computer, did not manipulate to get around program software that his wife put on the computer to make sure that he wasn't looking at pornography, and then just happened to have them file an indexed way, allegedly, people that collect this type of information do, and categorize it and in great detail, then he should go to trial. Otherwise, this is not the kind of thing you want a jury to see. Yes, people that do this kind of work for a living sometimes become very numb to it, but at the end of the day, it's not something jurors want to take a look at. All right, ladies and gentlemen, that's all we have for you today. Please take a look at our sponsor and check them out. We appreciate you doing that. Thanks for watching. We'll see you next time on Crime Talk, and we'll be back in the studio next week. Have a wonderful day.